Hi, welcome to My Court Coach. I'm Jaylyn. I'm going to be your instructor as we talk about Form FL-300, Request for Order. We're going to use this form in a non-emergency context. There is a different procedure for using this form in an emergency context, and you can review the videos related to that. That means that there are no temporary emergency orders. So this box will not be checked off, and we are not requesting any emergency orders whatsoever. We could be filing this form when we're filing for a petition to dissolve the marriage, when we're responding to the petition to dissolve the marriage. Maybe we're also filing this form because the other party wants to establish paternity and custody and visitation, or we're responding to the other party's request to establish paternity and child custody visitation. So you can file them alongside those petitions or those responses, or you could file them at any point in your proceeding. You do have to have a case number. You can't just file a request for order when there's not an underlying case. When I say underlying case, I'm talking about a family law case that already has a case number. But if you're filing it along with a new case that's going to be established, then it's okay for you to file it at the same time without the case number. So what kind of orders can be made using a request for order? Child custody orders, visitation orders, spouse support or partner support orders, child support orders, domestic violence orders, attorney fees and costs, property control, and anything else that you could possibly think of that is not an emergency. Now, the domestic violence order, that's typically in an emergency basis, right? But this just means that you already have a restraining order after hearing and you want to change it or terminate it. And so you would need to use this form in order for you to change or terminate it. So the notice of hearing is going to be made out to the other party. So if you are the respondent, then you would make this out to the petitioner because you're the moving party, you're the one that's requesting the orders. And so the other party needs to know when their next hearing is on those requests. And so you would write their name here and then check off if they're the petitioner. Or if they're the grandparent that's joined to your case, then you can, include other parent or party and write the grandparent's name, or any other person that is also part of your case and that needs notice of your upcoming hearing. You would include their name as well as the two. And so you do have to make 3 copies of this request for order for every individual that you are requesting their appearance and their participation at the upcoming hearing. And that hearing would be specified by the court clerk here, as well as the time, the department, and then where it will be. And most likely it's going to be in the same address as here. So if you have like 4 parties to your case that includes you, then you need to do this 3 times because the petitioner needs to have notice, the other parent needs to have notice, and whoever else is on your case also needs to have notice. And so you wouldn't write all 3 of their names, you would just write one of their names, and you would then prepare a brand new one and then write only the other person's name and then prepare a new one, and then you would provide this other individual's name, and that would be the final one. So you need to make 3 copies of that, of each single one, so that the court clerk can file it and so that you can provide the notice of hearing to each party. And then you should also, and you must, serve the request for order that you served on this person. You need to also make sure that the petitioner does, in fact, see that you have prepared a notice of hearing for the other party and that it has been completed for them as well. Now it says, warning, to the person served with the request for order, the court may make requested orders without you. So if you don't file a responsive declaration, serve a copy on the other parties at least 9 court days before the hearing, unless the court has ordered a shorter period of time, and appear in the hearing. So the court may make orders against you, for you, whatever that the other party is seeking at the time of the hearing with or without your participation. So it's very important that you respond in some fashion. Now, the court order, that's going to be completed by the court. If you filed a order shortening time, then the court's going to complete this. If the court has an order shortening time on the responsive declaration, then the court can go ahead and check off this box. If there's child custody recommended counseling that is part of your request for order, then this will be filled out by the clerk, and they'll provide the date and time as to which you need to appear. And then if there's emergency orders, which in this context, the court would not provide, this would not be checked off. And if there's any other orders the court is going to make, that's also going to be on an emergency basis, and that's not the context of this video. And also, sections 4 and 5 would not be within the context of this video because those also require emergency hearings to be set up. The only ones that would be completed if there's child custody and visitation and it's not within an emergency basis, that would be completed by the court clerk. This is section number 6. And the judicial officer signature must be there, and then the date in which it was filed. So you have your restraining order information. So you need to check off this box, whether you're the petitioner, the respondent, or the other party. You're going to attach a copy of the orders if you have it. You're going to identify the orders, where it's from, whether it's a family court case, a juvenile case, criminal law case, any case. You're going to go ahead and identify the information you need to identify that there is a restraining order in your matter, if there is in fact one. For child custody and visitation, you're going to write the child's name, the date of birth, who wants legal custody, who wants physical custody, because these are your requests, right? So typically it's going to be joint legal custody, and hopefully it will be joint physical custody. Just depends on what it is that you are looking for. So physical custody is the person with whom the child lives with, and legal custody is the person who decides health, education, and overall welfare. The orders that I request are child custody or visitation, and they're going to be specified in any one of these forms, or it's going to be as follows here. And typically, I like to just complete as follows and just write out exactly what it is that I am requesting for child custody and visitation, especially since the request does not include holiday time or anything like that. It's just the day-to-day request that we are making for custody and visitation. And then in order for the court to make this child custody and visitation request, they have to find that it is in the best interest of the children. So I need to explain to the court why I think it's in the best interest of the children. And usually it's, if you're requesting joint custody, it's in the best interest of the children because that is the policy of the state, and the other parent and I are good co-parents and good co-parents, and therefore joint custody is in the best interest of the children. Or I should have primary physical custody because the other parent is not involved with their child rearing. All they do is just put them to bed, and I take care of the children 95% of the time. This is what I do. And so to maintain the status quo, to maintain the routine and the consistency for the children, this is why I think the schedule that I'm proposing is best. Something along those lines, you can kind of plug that in to see, and you can write whatever it is that you think is appropriate. If you always need more space, there's the attachments. You don't click on the attachments, but you create an attachment, the MC025, and you would go ahead and include that and just title it attachment 2C or attachment child custody and visitation request, whatever you think is appropriate. And then if you're requesting a change from the current order, then you're going to click off child custody and visitation. You're going to write the last date the court order was made for custody and visitation, whether it's legal or physical. The visitation order was filed on a particular date, and this is what the court had ordered. And so you need to inform the court of the existing orders. Okay, that's very important that you do that. So for child support, you're going to do the names and the age of the children, and then whether you're requesting child support based off of guideline which is the very common request, or if not by guideline, then some other monthly amount, and it could be lower or higher than guideline. And if you have a special needs child or something, then maybe that would be a reason why you need monthly support that's beyond guideline. You would need to identify that with the court. So an earnings assignment may be issued, and you can do an income withholding order. You can complete that with your request for order form. And then you want to change the current court order for child support filed on, and then you would write out the date of the current order for child support and what is the child support order. You have to complete an income and expense declaration or the financial statement, because you meet the requirements on the form that's on the FL-155. And the court should make or change the support orders because, and then you have to list what is the change that you want the court to make and why. Why is it the best interest of the children to receive X amount of support, or why the court should change the current support orders. And it could be something as they're not following the current visitation schedule that's outlined by the court order, and therefore I need the child support orders to reflect the actual timeshare. Something along those lines would help. Or there's been a significant change in the incomes, and that's why you're requesting a change in spouse support. Or there's been a huge decrease in income, and therefore we need to change the child support. So whatever you find appropriate there. And then for spouse support, an earnings assignment order for support can be completed along with, you don't file it with your request for order, but you can go ahead and have one completed ready for your hearing. And then the amount requested, whatever you think is appropriate. You want the court to change or end the current spouse support order, which was filed on what date, and how much is the spouse support order currently. You're requesting the court to modify or change the spouse support because there's already a final judgment in your case, and you've completed and attached this FL-157 form, which is spousal or partner support declaration, or a declaration that addresses the same factors covered. And essentially those factors are the 4320 factors, Family Code Section 4320 factors, and it's actually best to just go ahead and use this form, because there have been times where I've seen parties use the information that they think is listed on the FL-157 and they put it in a declaration form and they miss a factor, and then the courts can deny the spouse support modification based off just that. So these are very important to go through the FL-157 and to just use that form, and you're not encouraged to complete your own declaration on that. So you've completed and filed a current income expense declaration in support of your request. So you need to have that when you file your request for order. At least make sure that's filed 16 court days before your hearing. And the court should make change or end the support orders because, and then you have to specify why the court should make change or terminate these support orders. And to change it or to end it, I mean, the usage of the word that the other party is self-supporting, or there's an income increase or income decrease, that would help bolster your argument. And the reason why you should make court orders that are in my favor for spouse support is because I'm in need of spouse support and the other party earns triple the income that I do. And this is my first request for spouse support and I'm in need of it. And the other party has the ability to pay spouse support as well. So property control, again, this box is not going to be checked. There is no request for temporary emergency order here. And you're going to include who should be given exclusive temporary use and possession and control of the following property that you both are buying and or leasing, or you both own and or rent. And you include those properties here. If there's more than one, identify more than one. And then whoever should be ordered to make the following payments and debts and liens coming due while the order is in effect. And you're going to write who it's paid to, what it's for, the amount, and the due date. And then if this is a change from the court order for property control, then you need to write out the date. And if you need more or additional information, then you can complete a different sheet like an MC025 and just label it attachment 5D or attachment to FL-300, property orders, whatever is easiest for you. And then the attorney's fees and costs, you're requesting attorney's fees and costs. For attorney's fees and costs, you're requesting attorney's fees and costs which total a certain sum. You filed the following to support your request: so an income and expense declaration, a request for the attorney's fees and costs, or a declaration that addresses the factors covered in that form. It's actually just best to just use the form. And then a supporting declaration for your attorney's fees and costs, which is the FL-158. Again, best practice to just use that form than just reinventing the wheel and creating your own declaration. The domestic violence order. This is not the form to use to get a domestic violence restraining order. This is the form to change or end it. So you would have the filing date of the restraining order, whether you want the court to change it or end any of the stay away, personal conduct, move out, or any protective orders made. And you would need to tell the court what the changes you are wanting to make and why you want to make those changes or end the restraining order that you currently have. And then any other orders that you are requesting, you would just write it here, like request to sell the home or request for issuance of passports, whatever it might be, you go ahead and request it right there. And then time for service. This is only going to be completed under an emergency basis. So if the court does grant you an emergency hearing and does grant you shortened time, then you would go ahead and complete this. But for purposes of this video, it's not relevant for us. So for number 10, facts support the orders that you are requesting, and the facts that you write and the facts that I write and support and attach to this request cannot be longer than 10 pages unless the court gives me permission. So more likely than not, this is not going to be enough information or enough space for you to provide all the information that you need for your request for child support or spouse support or custody and visitation. And so you would use the MC025 as an attachment, or better yet, the MC030, and then maybe attach the MC025. And you could, if you wanted to, just type attachment 10 on the MC025 and include that as a declaration, then you can certainly do that as well and attach it to this request for order. There really is no specific way to do it, but so long as you meet the rules under the California Rules of Court. And then you're going to need to date it, you're going to need to print your name, and you're going to sign it. Make sure that you're going to make 3 copies of this, or at least sign one, then make 2 copies of it, send it to the clerk, or go to the business office and show it to them. Every time you do file a request for order, it's a $60 filing fee, and add $25 to that. We hope that you found this helpful, and best of luck.